Hello, everybody. Thank you for joining us today. So we're going to get started right away. So welcome to Black on Poverty Law Part 1. My name is Khalba Saleh. I'm a community legal worker at the Black Legal Action Center. And we've organized today's webinar to talk about anti-Black racism, or ABR for short, as we'll be referring to it. What it is, how to identify it in casework, best practices on how to make arguments in various areas of law, including immigration, housing, employment, and social assistance. And to give caseworkers tips and strategies on how to recognize and challenge ABR in their casework. This is the first of a two-part training. The next one will be on March 22nd at 12 p.m. So you can register for it also on Eventbrite. The session has been approved for 1.5 hours of EDI professionalism. And a few housekeeping points before we move on. You can turn on the live transcription for the webinar by clicking the CC button at the bottom of your screen on the bottom menu. Please note that this webinar is being recorded and will be posted on our website. So the Black Legal Action Center, I'll just introduce what we do. I'll introduce also our wonderful guest speakers, and then I'll pass it over to my colleague, Piera Savage, to provide some more context for the rest of the presentation. So BLAC is a community legal clinic. We provide free legal services to Black residents in Ontario, and we work to combat individual and systemic anti-Black racism. Before I begin, I also want to acknowledge that the land that we're speaking to you from today is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and right now home to many diverse First Nations, Inuit, and Métis peoples. This land is covered by Treaty 13, signed by the Mississaugas of the Credit, and the Williams Treaty, signed with multiple Mississaugas and Chippewa bands. We also recognize the history of this land as a site of oppression of Black people and the relation between history of enslavement and settler colonialism. And it's important to frame this conversation through that lens as we recognize our position in relation to this land. I'll be introducing our speakers right now. Oh, and before I go on, I just want to let everybody know, so each of our speakers is going to be speaking for about 15 minutes, and then if we have time, hopefully we'll have a bit of a Q&A in the end. So please add your questions to the Q&A, and any discussion can also go in the chat. If you're having any trouble, you can message the panelists and let us know if there's any issue with that. So our first speaker is going to be Yodit Edemariam. She has been a lawyer at the Rexdale Community Legal Clinic since 2010, the year she was called to the bar. Since October 2019, she has also been in the role of Director of Legal Services. Prior to Rexdale, Yodit articled at Parkdale Community Legal Services and was a placement and summer student at Legal Assistance Windsor. Yodit has a particular interest in eviction case based on allegations of illegal activity and impairment of safety. Welcome, Yodit. Thanks for joining us. Elsie Dickson is a staff lawyer at Jane Finch Community Legal Services and has been working in the clinic system since 2006, practicing in all of the clinic's practice areas, but with a specialty in social assistance. She's a member of the SAAC Steering Committee of Social Assistance and co-chair of Clinic Access to Justice Collective. She was called to the bar in Ghana in 2001 and has 2 postgraduate degrees from Oxford University and Queen's University, and has been a member of the Ontario Bar since 2011. Prior to joining Jane and Finch Community Legal Services, she has worked in private practice in the areas of civil litigation, minerals, and mining law, while doing pro bono work with vulnerable communities in Ghana, particularly in the areas of women and children's rights. And Nicole Guthrie, oh, and thank you for joining us, Elsie, and Nicole Guthrie, who has been working at the Don Valley, formerly Flemington, Community Legal Services since 2011 as a staff lawyer, and she works almost exclusively in immigration law, which she'll be talking to us today about. And finally, John No, who is a staff lawyer at Parkdale Community Legal Services. After articling with the United Steelworkers, John worked for community advocacy and legal center in Belleville, Ontario, where he helped with the center expand employment and law services. In addition to employment law, he practiced social assistance. In 2011, John joined Parkdale, where he's a workers' rights division staff lawyer. His main practice areas are wrongful dismissals, employment standards, employment insurance, and human rights. Thank you, everybody, for joining us. So the BLAC Legal Action Center is a community legal clinic working to combat individual and systemic anti-BLAC racism. We work directly with BLAC people experiencing anti-BLAC racism, and we also conduct policy reform and public legal education to combat it at a systemic level. Our vision is a society where anti-BLAC racism is named and meaningfully addressed, where the humanity and dignity of BLAC people are centered, where the laws and the legal system are reflective of the real experiences of BLAC people, and where racial equity and full participation of all BLAC people in society is achieved. Anti-BLAC racism refers to policies and practices embedded within Canadian institutions that reflect and reinforce beliefs, attitudes, prejudice, stereotyping, and discrimination that is directed at people of African descent and is rooted in the unique history and experience of enslavement and colonization in Canada. We want to present this definition at the very beginning, so it helps frame the rest of the conversation that the rest of the speakers will be discussing. So please keep that in mind as we move forward. I also wanted to bring forward definitions of oppression, which is discrimination backed up by systemic or structural power, sometimes referred to as institutionalized power, including government, education, legal, and health systems, and oppression in the legal system, or recognizing oppression means recognizing the institutional barriers and how the system contributes to the issues that people experience within society. And also to bring forward the definitions of white supremacy, which is a political, economic, and cultural system in which whites overwhelmingly control power and material resources. Conscious and unconscious ideas of white supremacy and entitlement are widespread, and relations of white dominance and non-white subordination are daily reenacted across a broad array of social settings and institutions. It's also important to recognize how much of white supremacy is invisibilized in our day-to-day lives and within these institutions. So I'm very grateful to be hearing from all these speakers as they discuss how to move through that. And now I'll be passing it over to my colleague, Piera Savage, staff lawyer at the BLAC Legal Action Center.
Hello, everyone. Thanks for joining us today. And thank you, Hilda, for those introductions. I'm just going to talk a little bit about the areas of law that we practice in, but I'm going to focus on the 4 areas of law that we're talking about today. Before I do that, I just want to mention, I know that since the summer of 2020, clinics and organizations more broadly have taken time to think about racism and specifically anti-BLAC racism and how it impacts the work that we do in poverty law. I think it's fair to say that there are far more conversations happening today about this than when I first started in the clinic system about 6 years ago. So today we won't be getting into the deeper definitions of implicit bias, microaggressions, macroaggressions, etc. There will be more of that in our second training, so please join us on March 22nd. But I just want to encourage people to keep learning, to keep reading, and to continue naming racism in your work at every opportunity to ensure access to justice for BLAC clients. So as I said, I will start by sharing a bit about BLAC and the kind of cases that we do. I'll focus on employment, housing, social assistance, and immigration. But you can see from this slide that our practice at BLAC is much broader than that. We predominantly take on human rights cases. We assist clients with police complaints, and we advocate in the realm of education and much, much more, which you can see there. Oh yes, this is another slide that shows a bit more of the work that we do. And I'm just going to leave this with you to look at just because we don't have that much time today. So I'm going to skip to the next slide. So the themes that we see in our employment intakes, they reflect the reality of BLAC Ontarians and Canadians. So let me start with some statistics from Stats Canada. This is all available on their website. So basically, Black folks make up a small percentage of the population, 3.5% in Canada, 19% in Ontario, and 52% of the Black population is made up of new immigrants predominantly living in Ontario. However, despite their willingness to work, Black folks have one of the highest unemployment rates in Canada at 13.1%, which is 70% higher than non-racialized folks. There are significant racialized wage and employment gaps in Canada due to systemic racism in hiring and promotion, de-skilling of immigrants due to non-recognition of international credentials and experience, and use of police record checks to discriminate against applicants. This is consistent with what we see in our intakes. Clients face discrimination. Sorry, next slide. Clients face discrimination. I just lost my spot here. Yes. Clients face discrimination in the hiring process. They encounter both overt and covert interpersonal racism, which can affect their ability to advance in their careers. They may not be the right fit for the office, which is code for this person doesn't fit into this white Canadian space. Sometimes a Black employee is set up to fail by not being given the right training and onboarding. And then after being put on a performance improvement plan, they're terminated. Clients who speak up about racism in the workplace are terminated. And Black immigrants face additional barriers. They may not speak English or French, their education might not be recognized, which may put them in a position of having to take on more precarious employment. So at BLAC, we assist clients with applications to the Human Rights Tribunal. We also offer summary legal advice or referrals on the employment element of their case to explore the potential legal avenues available to them in different forums, which I'm sure we're going to hear about more from John in his presentation. So next, I will talk about housing. Once again, just a bit of context. Black tenants face many barriers and obstacles in Ontario, such as economic barriers, cultural differences, discrimination by landlords, which can reinforce racial segregation and push folks into living in poor living conditions. There have been recent studies in Toronto and Montreal that expose exclusionary screening methods, refusal to rent, or imposing financial barriers to renting, like asking for 6 months of rent to be paid upfront. A large number of our community across Canada and Ontario are living in housing below their standards. In 2026, it was 20.6% of Black tenants. So when we say below their living standards, that means that they were living in housing that cost more than they could actually afford. And it was crowded or required major repairs. There was also the recent Wellesley report that showed that there's a clear link between race, poverty, and evictions in Ontario, and that Black people are at a much higher risk of for eviction. Next slide. So the kinds of cases that Black sees also reflects this reality. We see clients who are being evicted by a racist landlord who has said explicitly racist things to them. We see tenants living in toxic environments with a racist neighbor or superintendent who refuses to do any repairs to their unit. We see over-policing by landlords and neighbors, child welfare involvement, and systemic racism in the force of policies that have a disproportionate impact on Black families, like illegal act evictions, which Yodit will be talking about shortly. So when it comes to housing, at BLAC, we assist clients at the landlord and tenant board if there's an element of anti-Black racism in their eviction matter, or we file complaints to the Human Rights Tribunal, and we often engage in informal advocacy with landlords. Next slide. So I will refer to the Color of Poverty, Color of Change fact sheet. So they have many great fact sheets on their website, which are just jammed full of stats and numbers. But I'll highlight just that in 2016, people of color have a low income rate of 21.3% compared to 11.5% for non-racialized Ontario residents. Recent immigrants had a low income rate of 31.4%, which was more than twice the rate of 12.5% for non-immigrants. Racialized immigrants are more likely to experience the highest low income rates. Folks who are facing unemployment and living in poverty often turn to Ontario Works and ODSP for support. And at this point, these services don't collect race-based data, but I'll just share some of the kinds of situations that we see at BLAC when our community seeks assistance from social assistance. So we often see caseworkers and decision makers who may use clear and direct language of a discriminatory nature or indirectly discriminate against the client. You can go to the next slide, Paula. And some incidents of discrimination may be summarized as a client being accused of lying about needing social assistance, lying about having a disability, differential treatment. So that's often when there might be an altercation at an office or something and our client is trespassed while perhaps another non-Black person involved in this incident is not, and our client is labeled as the aggressor. There are instances of higher scrutiny. So workers asking clients for an impossible amount of documentation and then cutting off benefits if that can be provided. And this is like slightly separate, but in its own category, medical racism, but it does connect to ODSP. And we have had a few calls recently about clients who are trying to apply for ODSP, but their doctors are underreporting their impairments on their applications. And we know that that's an issue that Black folks face discrimination in the healthcare sector. And I will obviously save this topic for another webinar. It's a whole other thing, but I thought I would mention it here because I do think that it's something that we're starting to see more awareness around. So in terms of social assistance cases, we file applications to the Human Rights Tribunal. We advocate informally with workers. And in terms of medical racism, we have assisted clients with complaints to the College of Physicians or nurses when there's an element of anti-Black racism related to healthcare services. So I'm just looking at the time and I'm seeing that I'm running out of time, but the next slide is about immigration. I just thought I would share some information about like the population of Black folks in Canada. Like I thought it's interesting that 200 ethnic or cultural origins have been reported by the Black population in Canada. And the 10 most frequently reported origins are amongst the Black population is Jamaica, Africa, Haiti. So you can read this here, but obviously the landscape has changed quite drastically in the last few years. So we just see predominantly folks from Jamaica and Haiti, and more recently there are more folks coming over from Africa. And so I know Nicole is going to get deeper into the history of immigration in Canada, but if you can go to the next slide. We can see that anti-Black racism manifests in immigration policies. The fact that Canada doesn't impose a maximum sentence for immigration detention. When we look at determination of risk and how that is sort of assessed using Western standards, and disproportionate status and visa denials, and migrant worker rights. So as I said, we'll hear more about this from Nicole. We don't offer immigration services currently at BLAC, but we are engaged in law reform. And if there's time at the end, maybe Hulda can talk a bit more about that work that we're doing. So before I move on to our speakers, I wanted to highlight a few Law Society rules that I know we're all familiar with, but I'd like to suggest that we look at these rules, keeping in mind our role as caseworkers to combat anti-Black racism and the work that we do. So the first one is 2.1-1. A lawyer has a duty to carry on the practice of law and discharge all responsibilities to clients, tribunals, the public, and other members of the profession honorably and with integrity. And commentary connected to this rule states that a lawyer has special responsibilities by virtue of the privileges afforded the legal profession and the important role it plays in free and democratic society, and in the administration of justice, including a special responsibility to recognize the diversity of the Ontario community, to protect the dignity of individuals, and to respect human rights law enforced in Ontario. And moving on to 3.1-1, I won't go through all of this, but this talks about being a competent lawyer, meaning a lawyer who has and applies relevant knowledge, skills, and attributes in a manner appropriate to each matter undertaken on behalf of the client. And then there's a very, very long list of things that I would highlight section H, which I think might be on the next slide. The one after. Yeah. So yeah, just recognizing H, which says recognizing limitations in one's ability to handle a matter or some aspect of it, and taking steps accordingly to ensure the client is appropriately served. And lastly, rule 5.1-1, when acting as an advocate, a lawyer shall represent the client resolutely and honorably within the limits of the law, while treating the tribunal with candor, fairness, courtesy, and respect. Next slide. Great. And I'll just highlight part of the commentary here, which says in adversarial proceedings, the lawyer has a duty to the client to raise fearlessly every issue, advance every argument, and ask every question, however distasteful, that the lawyer thinks will help the client's case, and to endeavor to obtain for the client the benefit of every remedy and every defense authorized by law. So all of this is to say that we have a duty as lawyers to raise every argument for our clients. This means that we have an ethical obligation to raise arguments that relate to anti-Black racism. We don't have the option of saying, seems like there might be a layer of racism or discrimination going on here, but I'm not entirely comfortable talking to the client or bringing it up. We know now that this is, well, we should have always known, but we definitely know now that this is not good enough. We have the duty as lawyers to represent our clients with vigor, and we have the duty as lawyers to discharge our duties with honor and integrity. So one piece that we would like you to take away from this training, and this kind of goes back to section H of rule 3.1-1, is that we are here for you. We recognize that it can be tricky sometimes to recognize anti-Black racism. It's not always trumpeted with fanfare. It can be very subtle and insidious. So we can help you identify the issues and be a second set of eyes on a case. We can help you think of how to craft arguments and share any resources that we have. We want to empower clinic lawyers to take on these cases, and we hope that this training will increase your ability and confidence to recognize APR and to actively combat it in the various ways that we'll hear today from our presenters. So we would just love for folks to get in touch with us at BLAC for consultations. So keeping these rules in mind, I'd like to share a case study with you. It's the housing case. An elderly Black tenant from the Caribbean is facing eviction from her subsidized unit for hoarding. By the time she comes to you for help, she's already had extreme clean come to her unit. She's had a broken mediated agreement. The client tells you that her living room is full of barrels that she wants to send home, tubs of coconut oil, and clothes she needs to organize to put in the barrels. She moved into this 1-bedroom from a 3-bedroom house. She has back pain and is on ODSP. She tells you that the first time Extreme Clean came to her unit, they threw out a bucket of her coconut oil without asking her, so she was reluctant to let them in again. So keeping in mind the rules that we just went over, how can you advocate for this client? What arguments can you make at the LTV? So feel free to put responses to this in the chat. We'll come back to this case study at the end. Or you don't have to put it in the chat, we can just talk about this at the end. But now I would like to hand things over to our first speaker, Yodit.
Hi, everyone. Thanks, Piera, and thank you, Calda, for organizing this and for having us. I think my slides are going up in a moment. Thank you so much. All right, so in my comments today, I will talk about three things. I'll first briefly talk about the context of anti-Black racism and eviction, and Piera, you've touched on some of these issues already. Thank you for that. I'll then discuss three recent eviction cases relevant to raising arguments around anti-Black racism. And finally, I'd like to highlight why illegal act eviction cases in particular are such an important area of work for clinics to take on in this particular context. So we could go to the next slide, please. So not to repeat too much, but a few things that I'd like to highlight in terms of the context are from two resources that are included in this slide and the next slide, in particular from the Wellesley Institute report that Piera mentioned already from August 2020, as well as the Ontario Human Rights Commission. And in short, what these two resources highlight, amongst many other issues, but what these two resources in particular highlight are that Black Ontarians face discrimination in searches for rental housing. The 2016 census tracts in Toronto with a higher percentage of self-identifying Black renters have significantly higher eviction filing rates. In terms of law enforcement and policing, the Ontario Human Rights Commission confirmed in 2020, again, what has long been known, that there is a disproportionate burden of law enforcement on Black communities in a way that is consistent with systemic racism and anti-Black racial bias. Black communities in Ontario are, in short, overcharged and over-policed. And of course, there's the disproportionate impact of the pandemic on Black communities, Indigenous people, and communities of color. So that's a little bit of the context in which we're doing this anti-eviction work. We can move through the next slide and then on to the next one. So these are just a couple of resources. So I'd like to highlight some recent case examples. These are three examples to discuss from over the last year. As we've heard, BLAC is doing also incredible work in this area, and I'm going to highlight these three that have been actually argued by people in the clinic system. And I know that caseworkers across the system are already making lots of creative arguments in these areas, and these highlight some of the things that can be raised in eviction cases. So the first case, the citation is there. It's not yet posted on the CRO. And it involved an own use eviction application by a landlord. The decision was rendered in August 2021. And it involved an own use application where the daughter of a landlord was intending to move into the unit. And in the unit, there were living 5 young Black tenants who were living on very limited fixed incomes. And the clinic representative, Kwan Sen Wen from the Rexdale Community Legal Clinic, raised arguments not only around income, the impact of eviction in relation to that, and being able to find a new unit in the city of Toronto, especially considering this was already a pretty precarious rent splitting situation, but also the question around race and the particular impact on these 5 young Black men of the pandemic in particular. And so in response, happy to say that the application was actually dismissed, and the board did a really great weighing of basically fairness between the landlord and tenant, and found that somebody needing extra space, i.e. the daughter of the landlord, was not something that would trump the rights of five tenants living in this situation. What's interesting though is the decision maker does not include specifically comments around anti-Black racism in the decision. Instead, the board focused on affordability issues and high Toronto rents, and of course the likelihood of homelessness. And I've posted the paragraph here where that sort of balance of fairness was considered. And the theme in the cases I'm raising as well is sort of to talk also about an opening, right? So to talk about what might be possible. So if the board is starting to be able to consider and actually finally take judicial notice of things like affordability issues in Toronto and Ontario more broadly, I think there's hope to be raising these questions. We can go into the next slide, please. The next case was argued by Ryan Hardy at the Advocacy Centre for Tenants Ontario. Unfortunately, it is under a publication ban, so I can't provide the citation. We don't have the case, but Ryan's happy to share the actual resources that were raised, the arguments that were raised. And this was a case involving arrears owed by a tenant, and they were a high level of arrears. And the caseworker raised arguments under Section 83, which is around relief from eviction based on social science evidence. And I've posted here the resources that are actually quoted in the decision and relied upon in the argument. And as well, a case I'm sure many of you are aware of from the Court of Appeal around relief from forfeiture in the commercial context, which I think can be really useful in our eviction work. And as a reminder, in that case, there was a great integration and recognition, again, of judicial notice of anti-Black racism, systemic racism, and the impact in the particular case at bar. And the court in that case said, for instance, confirming that the application judge applied these concepts appropriately, said that the application judge was entitled to take judicial notice of anti-Black racism in Canada. He found that whether the landlord's racial stereotyping was conscious or not, it was a matter he could take into account in the exercise of his discretion to grant relief from forfeiture. As he put it at paragraph 38, the societal realities pertaining to Black business people, like the tenants, must be factored into the exercise of the court's discretion in considering equitable remedies like injunctions and relief from forfeiture. And we'll go to the last case example. So this decision is from the divisional court. It's a wonderful decision argued by Kyle Warwick and Anna Rosenbluth in the clinic system, and really confirms the need for the board to apply Section 83 in particular ways and to take that requirement very seriously. Now, while as far as I know, anti-Black racism was not raised as an argument, the reason I'm highlighting this decision is because it is divisional court, it's binding. And again, it provides this sense that at least the court is willing to take into consideration social science evidence around a very difficult rental market like in Toronto. And so questions of affordability really at least are becoming recognized and are becoming a theme, and again at the level of divisional court. And so the invitation is of course to do that as well with arguments with anti-Black racism, right? That we can use this kind of case law as a precedent just in terms of taking into consideration things that are sometimes outside of even the exact relationship between the landlord and tenant. And if you could go to the next slide, please, thank you. So finally, I'd like to touch on why illegal act evictions in particular are such an important area of work for clinics to take on in this entire context. So for those of you who do not practice in housing law, the Residential Tenancies Act allows for eviction based on allegations of illegal activity either in the residential unit or the complex. It's important to note that no criminal conviction is necessary. The criminal process, if there is one, does not first need to conclude, and the board generally does not grant adjournments for that process. And if only one person or their guest is facing the allegations, an entire family or an entire household faces eviction, and they can legally be evicted for the actions or allegations against one person. And I'll go to the next slide, is something I'd like to talk about in a bit more detail, which is sort of a plug and a recommitment, I think, for clinics to take on these cases. And before I go into this list, I'd like to go back to Calda and Piera's context in terms of systemic racism, and to think in each of these points how obviously each of these things will more disproportionately impact our Black clients and Black tenants in Ontario. So first of all, these cases are very complex. They wade into criminal law. There's overlap with criminal law. The kinds of evidence that need to be collected and gone through are very complicated. There are questions around bail conditions, talking to the criminal lawyer who might be involved. There are questions around youth offenders and understanding the interaction there and making sure that youth offenders' information is protected. And the plug is essentially that it's precisely because they're complex that clinics, I believe, should be taking them on more than not. Where we might be able to give summary advice, for instance, for a few arrears cases, not to oversimplify that, but where we might be able to do that, I think this kind of complexity is the kind of case that warrants full representation. The next point is balance of probabilities. So you have this strange world in which the criminal law is coming into a civil process, and the standard of proof becomes balance of probabilities, where some of these allegations, if they involve weapons or drugs or other serious issues, face beyond a reasonable doubt in the criminal context, and because there is a clear recognition of the consequences, right, and the outcomes that are possible based on those serious allegations. The next point is about double jeopardy, right? So the question of somebody and their entire household, potentially their entire families, we're talking about grandchildren, grandmothers potentially losing their homes, which is not replicated in the criminal process. And it's not replicated if I, for example, own my home and my son or daughter does something, I'm not going to face the loss of my home. So there's this real particular impact on renters, and I would say particularly on low-income renters. The other thing that we've noticed, at least at Rexdale, is often casual information sharing between the police, who often act as witnesses, and that interaction with social housing providers, which is a huge concern. I've noted already the protection of youth offenders and trying to be very, this is part of, again, why representation can be so helpful, to be really careful about the ages of any accused and to ensure that their information is protected at the board. The consequences for social housing tenants. Now in law, social housing tenants who are evicted for these reasons face, I believe it's a 5-year bar to be able to access social housing again. So there's an additional consequence as well as loss of home, potentially loss of liberty, also the access to social housing and rent geared to income housing. And evictions overall must be based on a fair process, sound evidence, and proper application of the law. What we see a lot at the Landlord and Tenant Board is a sort of shock, a sort of, just being very persuaded by the allegations themselves, and not really holding landlords to the standard that they need to be held in terms of proving the allegations and proving actually that eviction is warranted, and that eviction is warranted against, for instance, an entire family. And there are, I think there's some critique around taking on these cases and what that means for a clinic's reputation or our relationship with a social housing provider. And all I'll say to that is, of course, we do merit assessments in every case. It raises interesting questions around what it means to serve a community, right? Who is the community? If a clinic is seen to be defending, for example, in a guns case, what does that mean? But I go back to this point, right? That we're there also for the process and to ensure that the process is fair and carefully applied. And finally, I would say challenging narrative. Again, we're talking about a context, and I work in Rexdale. Our clinic is located in the northwest of the city, and one of the most profound and beautiful things I've seen in illegal act eviction hearings is, is not the brilliant legal arguments necessarily we're always meant to raise, but the ways in which tenants have taken up space and also reclaimed a narrative about their communities, and the ways in which, for example, a place like Rexdale is often talked about. And I've seen, for example, a Black mother talking about this community being her home, the way that she's been part of building it, her connections to the community, having a garden with her neighbors. And I think there's something very, very powerful about that, to tell a different story and to actually address bias in a way that allows clients and tenants to do that in their own voices. So to conclude, because I know I'd like to pass it on to the next presenter, in relying on illegal act evictions as a point of focus, the invitation is not only to recognize anti-Black racism in specific fact patterns or in relation to only particular individual clients, but also to integrate an understanding of anti-Black racism as a baseline, a systemic context, and to connect your client to that context. In other words, I'm simply suggesting that anti-Black racism matters in every single case involving a Black tenant being evicted. And illegal act evictions are a particular and stark example of this. And on the last slide, I've posted a couple of CRO resources that you might find really helpful. The first is around, it's based on evidence around mold, but has some great references in terms of the Landlord and Tenant Board rules, the Residential Tenancies Act, and the SPPA in terms of bringing in social science evidence into the hearing. And also there's a December 2020 memo on, November 2020 memo on discretionary relief from eviction under Section 83. So those are great resources to use in this kind of work. Thank you so much.
Thank you, Yodit. Okay, while Helda is pulling up Elsie's presentation, I want to say thank you. You offered persuasive reasons for taking on these kinds of files. I like what you said about there being an opening right now in the tribunal, and just trying to, push these kinds of arguments forward while there is momentum. And I will pass this on to Elsie, who's going to be talking about social assistance and also talking more about Jane and Finch area and the work that is happening there.
Right, thank you very much. This has been a fascinating conversation already. And for me, the take home, and if there's anything I'd suggest that we walk away with, is that conversations surrounding anti-Black racism are really about creating an awareness for us as clinic workers, because it's not often that it's a clear black and white case where you can say, this is the issue and this is how I'm going to approach it. I'd like to suggest that we need to constantly have these conversations so that we build almost like a spidey sense so that we're able to notice and recognize the very, very subtle areas in which this manifests. And I'd like to suggest also that that happens more often than the clear, egregious cases. In social assistance in particular, you find that a lot of these conversations probably happen in educating our clients so they're better able to advocate for themselves, but also for things to be de-escalated and dealt with before it reaches a critical point at which, our involvement gets triggered. And so, can you move on to the next slide, please? I'm going to be speaking a lot about the Jane and Finch community generally, but also of anti-Black racism. Some of these definitions have already been referenced in previous slides. So anti-Black racism, according to Ontario, is anti-Black racism is prejudice, attitude. I'm sorry, I think I muted myself accidentally. That is directed at people of African descent and is rooted in their unique history and experience of enslavement and its legacy. Anti-Black racism is deeply entrenched in Canadian institutions, policies, and practices to the extent that anti-Black racism is either functionally normalized or rendered invisible. And I'd like to stress that really, because unfortunately we've gotten to the point where it is either this is what it is and we have to roll with it, or it's so subtle that it's near invisible. Next slide, please. It is also very pervasive. And sadly, even within the systems that are supposed to level the playing field and address inequalities, you will find tinges of anti-Black racism. The question is, how do we tune our minds to that and recognize it? And how do we navigate the system, challenge where it needs to be challenged, because that is what we need to do. But more importantly, I believe that educating our clients tend to come to us when they are in crisis. and we have to peel back the layers of those crises and deal with, loss of housing, an immigration appeal, or, social assistance matter. But interwoven with that at different levels is the issue of anti-Black racism. And as clinic workers, we can't just look at the end result. We need to be able to educate our clients so that walking away, they're better equipped to navigate the system and hopefully engage in the change that we need to trigger. Next slide, please. What I find interesting in all of this is that the province has a stated strategy and a goal, and that is the elimination of disparity outcomes for Black Ontarians in child welfare, education, and justice sectors by 2024 to align with the close of the United Nations International Decade for the People of African Descent. We're in 2022, and that's 2 years away. And I'm glad we're having these conversations, but it's also a stark reality that in 2024, chances are we still will be having these conversations. So it's an ongoing battle, and I'm glad that we have the opportunity to engage and think a little bit more critically about what it looks like in the kind of work that we do. Next slide, please. Now, the other thing that is of note is that Toronto has this radar through which they assess the health of a community. And it's interesting that each of these gauges of the wellness of a community actually reflects the work that we do as clinic system. So we're talking about economic opportunities, social development, participation in decision-making, healthy lives, and physical surroundings. And no matter what area of clinic law you're in, when you look through it through the lens of anti-Black racism, every single one of these markers impacts the work that we do. And in every single one of these markers, we find anti-Black racism. One needs to ask themselves as we engage with our clients, as we advocate on their behalf, as we try to solve their problems, how do we intentionally notice these things? There's a much broader conversation, but it trickles down into the day-to-day work that we do and the slide and the files that we work on. Next slide, please. More statistics, particularly with Jane and Finch as an emphasis. By 2036, racialized people will account for 48% of Ontario's population, and a disproportionate number of racialized people are living below the poverty lines. None of this is news to any of us. Poverty rates are much higher for children from racialized groups compared to non-racial groups for each generation. So for example, among children that were born in Canada and whose parents were born in Canada, third generation or more, poverty rate for racialized children is twice that of non-racialized children. Now, as diverse as the GTA is, the population of Black people in some neighborhoods is higher. Jane and Finch happens to be one of those neighborhoods. Next slide, please. And 58% of, I'm going to share some statistics in our catchment area. So 58% of the population in Humber Creek, which is one of the main riding in our catchment area, is made up of immigrants. 28.8% of those are refugees, as opposed to the city average of 17.8. 67.8, almost 70% of the people have certificate, diploma, or a degree, and yet the average household income is $65,000, as compared to $102,000 for the city of Toronto. 22% of the population is a Black minority. Next slide, please. I'm sorry, my screen has gone blank for a second. Let me just pull that up. Now, how do all of these statistics play into the work that we do as a clinic? Here are some examples of ways in which it shows up. Now, viewed through the lens of anti-Black racism and poverty, the numbers that I've just talked about become even more important because anti-Black racism occurs within this very real context. So the numbers we're seeing, percentages, etc., they're actually real lives. And anti-Black racism adds on an added layer of complexity and makes the province's vision and the work that we do even more critical. For example, in the scope of, within the conversation of social assistance, how do you handle the reluctance of well-meaning professionals who dissuade people from applying for benefits that they may legitimately be entitled to because of misguided perceptions of income maintenance? For example, a doctor who minimizes, impairments or restrictions because, don't apply for ODSP because it's just another means of keeping people of color down. Does race play a role in some of the information that is being required of recipients of social assistance and how that information is processed? What is the ratio of racialized people and non-racialized people who don't have a family doctor and who therefore have to rely on walk-in clinics? How does it impact their access to quality healthcare and the creation of a detailed medical history, which is critical for disability cases? What are the systemic barriers to the settlement or assimilation of racialized immigrants? For example, when we're talking of professionals who are requalifying, are there any practices which serve as added barriers preventing such individuals from meeting their obligations under various income maintenance laws? For example, local offices do not provide interpreters, and clients are expected to provide their own interpreters. And we find that some of our clients resort to relying on their young children, making decisions to pull them out of school so that they can attend appointments with them, or paying for interpreters out of their limited budget. Next slide, please. Now, in posing these questions, I'm not saying we have all the answers to them, but these are questions that we need to address our minds to. And we also cannot have this conversation without looking at the impact of the pandemic on vulnerable clients in particular. I found this quote, which I thought was very interesting, from Helene Gale, the CEO of Chicago Community Trust, where she says, if the general population catches a cold, the community of color catches pneumonia. The disproportionate impact of the pandemic on our clients, on top of anti-Black racism, just makes things a little worse. People hit hardest by COVID-19 are those who are economically insecure, refugees, newcomers, ethnic minorities, and low-income of people of color who work in service industries that put them at risk of being exposed to the virus. Critical information around COVID-19 is posted online, but that does not reach those who are without internet access or who are less likely to access the information digitally, such as seniors who are not digitally savvy. The pandemic is a great revealer, unmasking problems that have always existed: precarity in food, income, and housing. COVID-19 preys on poverty, starves people, deepens income inequality, and forms a dangerous liaison with domestic gender-based violence issues. All of this is from a publication on the impact of COVID-19 on lower income populations, a publication by the STOP. I'd like to suggest, and I'm sure most of you will recognize that people of color have been impacted to a greater extent, more and disproportionately more than others. Now, all the previous points, next slide, please. All the previous points I've raised so far have been client focused, but I do have to turn the lens on us very briefly to say that we ourselves as clinic workers can be victims or unintentional perpetrators of anti-Black racism. And so, you can get it from other professionals, from clients, from colleagues. Some of our practices and the policies we have may unconsciously perpetrate anti-Black racism. And I'm saying unconsciously because it is such an evolving area that we need to go back and look at our policies and tweak them and rejig them based on how more sophisticated and layered anti-Black racism is getting. We don't have a magic wand. Next slide, please. We don't have a magic wand to make the province reach its goal. I'm sure many of you have seen this visual in different forms. And I find that each of those vignettes shows a different aspect of the work we do as clinic practitioners. I would suggest that we begin to look at our work as a tool to dismantling the fence. And that's the last quarter of the image. Next slide, please. I don't have answers. I don't think anybody does, but here are some suggestions as to what we can do. And We need to talk about the issues, starting with an acknowledgement that anti-Black racism exists. We need to create and adopt best practices as clinic workers. We shouldn't be afraid to call out acts of anti-Black racism in our interaction with individuals and institutions. We should educate ourselves about the unconscious and automatic way in which it presents itself in the work that we do. We should educate our clients to recognize anti-Black racism, and in particular, the not so overt acts of anti-Black racism. Advocacy one-on-one and in group settings is critical. Let's use opportunities to engage with politicians at all levels of government, community leaders, civil society, religious bodies, schools, etc. Next slide, please. And this is my final slide. I found this image of the Gordian knot very intriguing, and it spoke to me because of the stick people. And the stick people reminded me of the clinic system and clinic workers. We are faced with this mangled knot of anti-Black racism. There's no beginning or end to it, and yet every day we try to unravel one small piece of it. Sometimes we make headway, and at other times we throw up our hands in frustration. Some scholars have argued that perhaps the ends of racism, like the Gordian knot, are not only deeply buried, but invisible, entrenched even in layer upon layer of intricate and delicate tangles of histories of social complexities. Legend has it that Alexander the Great stepped back after several unsuccessful attempts at unraveling this knot and drew his sword and proclaimed, it really doesn't make any difference, except that the knots need to be loosed. And then he proceeded to slice the knot in half. The challenge to us, I dare say, regardless of the area of law in which we practice, is that sometimes it's time to take a step back and collectively do whatever we can to end anti-Black racism in the communities that we serve. And that is my challenge to all of us today. Whether you work in immigration, whether you work in social assistance, whether you're an intake worker, how do we together work, regardless of the color of our skin? How do we acknowledge that this problem exists? How do we identify the ways in which it shows up in our practice? And how do we intentionally engage and hopefully entangle in this knot? Thank you very much.
Thank you, Elsie. Thank you for leaving us with these powerful images. I love the knot. I also like this idea of thinking about our work as a tool to dismantle the fence. I think that's something to keep in mind as we do this work, as we work to sort of develop that spidey sense that you mentioned at the beginning. And yeah, you left us with lots of interesting questions to ponder, especially around social assistance. What you said about like the doctor maybe discouraging a client to even apply for the SP, like that's a kind of insidious, sort of like almost invisible things that we're trying desperately to work against. So thank you for that. All right, up next we have Nicole. I think Nicole, you're going to be sharing your slides, right?
Yes, I will be sharing it.
Okay.
Okay, so I'm going to be talking more about navigating racial issues in immigration. Immigration is a little bit challenging when it comes to race because of the fact that it's not as overt as other areas of law. So I'm going to try to give a general sense of where immigration policy started and what we kind of need to advocate on more for clients in immigration law. So the history of immigration in Canada. So immigration policy in Canada, the first act of 1910 basically stated that the governor and council may by proclamation or order prohibit for a stated period or permanently the landing in Canada or the landing in any specific port in Canada of immigrants belonging to any race, deemed unsuited to the climate or requirements of Canada. So basically how immigration policy started was to decide who came to Canada based on race and other inalienable characteristics. This was in place for a long time until 1962 when it was prohibited. Looking at the statistics on immigration, it's very hard to see exactly where race is considered, but I kind of tried to look at all the countries where citizens need a visa to come to Canada and those that don't, and I pulled out the majority Black population countries, and if you notice, there's 4 countries where it's majority Black population who don't need a visa, and all the other countries, the citizens need a visa to enter Canada. So that kind of gives you an idea of exactly how immigration policy is in Canada. Generally, courts have said that there is no right to enter another country. So it's very difficult to establish a connection between race and immigration policy in Canada. The only real area of law where race plays an important role is Section 96 and 97 and seeking protection. And one of the challenges is showing that race is a factor, a contributing or determinative factor in applications. I also looked again on visa applications and the statistics on acceptance or refusal of visa by country. I couldn't find anything on that. I found information in visa acceptance rates, and I took a sample of offices from different areas of the world. So for example, in Kingston, Jamaica, if you're applying for a visitor visa or TRV, the acceptance rate is 70%, while someone in Nigeria, the acceptance rate is 30%. So there isn't really any clear indication of whether statistics are different for particular countries. Again, the more important area where race is an issue is refugee claims. So under Section 36, it specifically states that race is one of the enumerated grounds of seeking protection. There's no federal court case that provides a detailed analysis of this ground. In most cases, I found it was a contributing factor. In a lot of Roma cases, it was a factor, but I'll get into that later on. However, in the UNHCR handbook, paragraph 68 to 70 provides a description that race is understood as the widest sense to include all kinds of ethnic groups that are referred to as race in the common usage. The Court of Appeals has said that where race is one of the defining elements of a group to which a claimant belongs, then if that is not considered a ground, then it's an error. One of the, as I stated earlier, one of the groups that has been used most frequently is in the Roma claimants, and those were more recently in 2000. Race may be a reason why the client can argue that they are not responded to correctly. It's a soft factor. So for instance, if and mostly in Roma cases, again, if the police aren't responding because the person belongs to a certain minority group, police officers don't respond and enforce the law if they're being attacked. That's a soft factor that's considered in refugee claims. Some of the important cases that talk about race are Montano, which was about the clients were refugees from Colombia, and they were being attacked. The applicants did say that there was they were Afro-Colombians and they were being attacked, but unfortunately the court decided that they didn't refer to race as a specific factor in their arguments. It was referred to in passing that a comment was made by their attackers about their race. This is in contrast to Gonzalez, where race was established. The applicants in their BLAC repeatedly stated that race was one of the reasons they were targeted. More recently, under the previous government, I don't know, everyone remembers that DOC countries were established, and under the rule where certain countries were listed as DOC countries, these clients could not make a PRA for 24 months. The court in Fair decided that denying nationals from DOC countries access to PRA was not proportional to the government's objectives, and this was overbroad. This was a charter challenge case. It was challenged under Section 7 of the charter. And basically the court agreed with the applicants and said that this was overbroad and it couldn't be saved by Section 1 of the charter. In refugee cases, again, the case law has established that a history of discrimination against a certain group cannot be erased by good intentions of government. So even though the government says that we've changed the rules, we've changed the law, as long as the government is, race is still an issue in enforcement of the law, one of the grounds of which is state protection must be looked at. There is a number of cases that have confirmed this, more recently in Fedor. Also in Singh, the court has said that evidence of race and history of attacks. So this client was originally from Guyana. They went to the US, made a claim, went back home to Guyana, and each time they were attacked, they indicated in their narrative that they were attacked because of their race. They were Indo-Guyanese. And the court, the lower court, the RPD, said that race was not a factor. However, the federal court disagreed and said race was a factor that should be considered. In contrast, of course, there's always a Justice Annis decision in immigration, which is terrible. Justice Annis decided in Mudrak that extensive and substantive legislation that and other measures being undertaken should be treated as evidence that the government is trying to change and is trying to improve and provide protection for races, and dismiss the applicant's evidence of a history of racism. This was like in Hungary, and these were Roma claimants. They were claiming discrimination. They were attacked on the subway. They put forward evidence of history of discrimination against them, against similarly situated individuals. However, Justice Annis found that the government was making changes, and these changes were indications that state protection was available. The Court of Appeal dismissed the decision, dismissed the appellant's appeal, but mostly because of the fact that the issue of state protection and the availability of state protection was federal law. So again, bringing up race as an issue in immigration is pretty difficult and pretty complex. The courts, have decided that there is no right for a person of a certain race or from a certain group to enter. In permanent resident applications, race has been raised in a few cases. One of the big one is bigam, where in family sponsorships, there is a minimum necessary income, M&I, to be able to sponsor parents and grandparents. Bigam put forward the idea that because the client was of a minority group, and so was a low income, was a woman, was a single parent, she would not be able to meet the minimum necessary income. Unfortunately, the court found that family members, again, do not have an unqualified right to enter or remain in Canada. They basically said when Ms. Bigam left her home country and came to Canada, she made the decision to separate from her family. The fact that she's in Canada and having a hard time is not sufficient grounds, even though she's a minority woman who's a single parent. It's not a right for her to have access to bring her family outside of the M&I requirement. Again, this was confirmed in a recent case in 2016, saying that Section 7 does not contain a right to family reunification. Non-citizens do not have an unqualified right to enter or remain in Canada. In agency applications, race can be argued on grounds of hardship, especially in terms of country conditions. So country conditions back home, anything that has a direct negative impact on an applicant, and that includes unfair treatment of minorities. It can also be considered in immigration appeal cases where agency issues are raised. This include residency applications. So if a client is saying they don't meet the residency obligation, if they're raising agency arguments, race is one of the grounds that can be raised. If it's a misrepresentation application at IAD, race can also be raised. And Rowell is a good case to look at for that. One of the biggest cases that talks about hardship and H&C factors when considering Section 25 was, of course, Campesame. So evidence of discrimination experienced by the applicant or others can be used as hardship. This was affirmed more recently in 2018. So the applicants need only show that they would likely be affected by adverse conditions such as discrimination in their country of origin. One of the areas that I feel like the clinic and other caseworkers could advocate is caregivers. Caregivers under the current regime, which was changed recently, caregivers under especially the home child care provider pilot, skill set required for PR includes a certain level of English, postgraduate education. It doesn't match the skill set required by employers. A significant number of caregivers fail to meet the requirement for PR under the program. A lot of those caregivers are minority women. The recent caregiver applications opened on January 1st, and I think it closed within days. The number of accepted applicants was 2,750. There is still a lot of applicants who do not meet one, meet the requirement of the new program, or two, did not get the opportunity to apply. There's a lot of access to justice issues. There's a lot of issues around women and minority women and skill sets in that category. Farm workers. There's no real pathway to permanent residency for most farm workers. I know John will cover a lot of this in his presentation, but there is an agri-pilot project for farm workers. However, there is a language requirement and there is an education requirement. These requirements for permanent residents disproportionately affect, again, certain groups, Mexico and Caribbean farm workers, who either don't meet the education or language requirement because they don't speak with English well enough or they don't have the education. I've met a lot of farm workers who have been coming for years. Some have been coming for 15, 20, 26 years. They come 8 months out of every 12 months. So they spend most of their time in Canada, but they don't have a real pathway to permanent residence. I think that's something that the clinics and BLAC even should be looking at and advocating for, because it affects a lot of Caribbean workers. There is one area of immigration that I haven't really touched on because it's so complex. It's Section 36. So Section 36 is used quite frequently to remove a lot of and it disproportionately affects a lot of mostly young men from the Caribbean. It deals with inadmissibility. One of the best ways to assist with preventing removal under 36, and I'm happy to see that a lot of criminal lawyers have been coming and asking for these letters. It's providing opinion letters. So usually when clients go to court, if it's their first offense, the judges will want to know, and even the judges themselves have been recognizing that it's really important to look at the applicant's immigration status, if they're permanent residents or foreign nationals, to try to get a letter from a lawyer, an immigration lawyer, to assess the impact of removal rather the impact of conviction on their status. So again, it's really important for us to assist criminal lawyers and, you know, maybe provide education on getting opinion letters from immigration practitioners so we can assist in criminal matters. And I see I'm out of time, so I'll hand it over to John.
Great.
Yeah, thank you, Nicole. And yeah, in the interest of time, John, you can take the mic.
Great, thank you. Okay, so I'm just gonna share my screen. And I'll try to be very quick. Okay, so and it seems like we love statistics. So I also have some statistics. So this is the employment rate in Canada. It's from, I think this is around 2016. It is slightly different from the unemployment rate just because the questions they ask for the employment rate versus unemployment rate is a bit different. And so as you can see, the employment rate is lower. Now, interestingly, for the education level for people, I think roughly around what they call the core population, core age, roughly around 25 to around 59 for Black individuals, they actually have a higher rate of having a bachelor degree than the white population. But despite that fact, the unemployment rate is higher, or the employment rate is lower. There was also surveys done about experiencing unfair treatment or discrimination at work. As you can see, the numbers are higher if you're for Black individuals. Conversely, however, the level of satisfaction is comparable or higher than the rest of the population. And I'm going to kind of speak to that a little bit when we talk about different figures as to why that is, which is this figure, which is they ask after hardship, you know, do you bounce back? And if you're Black, you're more likely to say that you always bounce back from hardships, or that you often bounce back, and less likely to argue that you rarely or never bounce back, etc. So I think that speaks to the resilience of the population, despite the fact that they've identified that they experience more hardships, despite the fact they identify they experience more discrimination and etc. In terms of the optimism, in terms of the ability to kind of move forward, is the resilience is actually higher than the rest of the population. During COVID-19, the unemployment rate increased more among Black Canadians than non-visible minority Canadians in the context of the pandemic. And the COVID-19 has hit Black women especially harder in the sense that 31.7% of employed Black women work in the healthcare and the social assistance field, which is much larger than the non-visible minority woman population. while the numbers in trade, numbers in science field, etc., are fairly comparable, the numbers are not comparable when it comes to management occupation. Both Black men and Black women are less likely to be represented in management occupation compared to non-visible minority population. The Canadian numbers do not exist, but in the US figures, in terms of people who work in the gig platform, so Uber, DoorDash, Skip Dishes, etc., this is the breakdown with respect to race. Of course, US has different racial makeup than Canada does, but I don't think it will surprise any of us to assume to come to the conclusion that racialized individuals are much more likely to be in precarious gig economy work than white individuals. So in terms of the employment issues, so I kind of broke it down to employment standards, wrongful dismissals, and human rights issues. So what are some, focusing on employment standards issues, what are some employment standard issues often faced by Black workers? And again, so the employment standards are fair, you apply fairly mechanically. So the kind of the negative impacts that it would have on Black workers wouldn't be overt. It would be kind of based on, as a lot of the panelists spoke about, the disproportionate impact it has. Misclassification is a big issue. For example, as we spoke about, a lot of Black women tend to be in the care work industry, specifically care work through an agency. The foreign living caregiver program generally tends to be dominated by Filipino or Asian women. But in terms of the care work done in long-term care homes, in terms of people who already have residency, there are a lot of Black workers. And a lot of these care workers are misclassified. And so they're not necessarily getting minimum wage and not getting vacation pay, public holiday pay. They're not entitled to employment insurance if they lose their employment. Of course, impacts their CPP contributions, etc. And interestingly, the Employment Standards Act also provides less benefits to care workers who work through an agency. So, there is a provision called the Homemaker Provision, which is if you do homemaking services, which includes some care work, but also cleaning work, etc. And if you're employed through an agency or through what they call non-householder, then you are only entitled to paid up to 12 hours of work, even if you're working 24 hours, or even if you're working 16, 18 hours. So, so there's a cap. So you're actually providing free work if you're a homemaker. Other industries where the misclassification is rampant and it's mostly done by either racialized or Black workers, cleaning industries, security industries, fitness, health. Again, misclassification is rampant in those industries, and we also talked with the gig platform workers as well. We also now know that Black workers or racialized workers are more likely to do casual work, part-time work, temp agency work, especially immigrant workers as well. And we also seen statistics about how many Black immigrant workers or immigrant population there is in Ontario. Well, and they're less likely to be paid equally for the same work they do for permanent workers who are hired directly through the company. There was a few years ago, through a lot of lobbying and campaigning work, there was a victory won, which was the equal pay for equal work, regardless of employment status, that stated that if you're doing comparable work, it doesn't then, as a full-time worker who's employed directly through the company, then you should be paid the same, and you should not be paid differently merely because you're a part-time worker, merely because you're a temp agency worker, etc. And that would have had a huge effect on providing equity and equality in terms of being paid properly, because it probably doesn't surprise you to know that Black workers are being paid less than white or non-visible minority workers. But that would have made the pay inequity, would have reduced that gap. Unfortunately, when the Ford government came in, they rescinded the equal pay for equal work based on employment status. So that is something that we want to continue to fighting for. And of course, lack of paid sick days, again, especially if you're working in the health industry, in the context of the pandemic, it's very crucial that we have that. You may have heard that the government has instituted a temporary paid sick days, which is a lot of things wrong with it. It's only 3 days. It has to be in the context of COVID-19. It's temporary. And also, it's not the employer who's actually paying for it. It's actually subsidized through taxpayers or the workers themselves indirectly. So what can we do? When it comes to misclassification issues, the political landscape with respect to the Ministry of Labor doing a proactive investigation is actually very poor. They used to do more, so if you filed a claim and the Ministry of Labor determined that it's not just the individual worker that's being affected, it's actually a workplace-wide issue. For example, misclassification, the Ministry of Labor was willing to do some proactive investigations. They weren't doing a lot of them, even historically, but they were willing to do some. However, under the current regime, they've practically stopped a proactive investigation. So despite our urging for them to do so. So you may find it very difficult to convince the Ministry of Labor to do a workplace-wide investigation. What may actually be more helpful is to request a ruling from the Canada Revenue Agency with respect to misclassification, because they may be more willing to look at one individual claim and then actually look at the wider workplace. So it is a fairly simple process. If you do employment law services, I would encourage you to kind of expand into doing CRA rulings as well. If filing an ESA claim, consider perhaps pushing for an ORB appeal instead, because ESO decisions are neither binding nor persuasive nor public. So ORB decisions, so for example, there is some appeals happening with gig platform workers, or there will be appeals happening. Recently, there was a case involving an Uber driver, a racialized worker as well. Wasn't a Black worker, but was a racialized worker. Uber is planning to appeal that to the Ontario Labor Relations Board. So if clinics wants to kind of use this as a time to kind of get into that movement, it may be time to do it now. Be part of the Justice for Workers campaign, fighting for paid sick days, fighting against precarious forms of employment. And of course, the other thing that you can also do with your clients or group of clients is to discuss unionization. Now, of course, unions are not perfect by any stretch of imagination. There could be a lot of problems within unionized workplaces as well. But ultimately, we can't argue with the statistics or the facts. If you're a unionized workplace, the unionized workers, especially for workers in what we may call blue collar work or historically underappreciated work, they do tend to get higher pay than non-unionized counterparts, benefits, etc. So that is actually something that you may wish to discuss with your clients, whether that is actually something that is possible in their workplace as well. Human rights issues are often faced. Of course, there's the overt racial harassment, but I think the more difficult for caseworkers is the more subtle forms of discrimination, being denied promotions, pay raises, etc. At our clinic, we get decent number of clients coming in speculating that they didn't get hired or they didn't get a pay raise or promotion or etc. Or they were picked to be laid off and race had a part in it. It is on a pragmatic point of view or practical point of view, it is challenging. Unless the employer really did something silly in terms of being very explicit about the discrimination, it can be difficult to prove. There are some tests that the HRTO or other human rights regime has applied to determine whether there was discrimination or not. There's what they call a Shakes test. There's also what the 4/5 rule, which is often used in the US. The 4/5 rule is if the company's decision was non-discriminatory, you would assume that 80% of the I guess the managers, let's say, would reflect. Sorry, let's put it this way: if, let's say, there are 10 Black workers in the company, then you would, or actually, let's say there's this about 20% of the workers in the company are Black, then you would assume around 16 to 20, I can't do the math, 16 to 24% of management would also reflect, would also be Black individuals. So that's the 4/5 rule. As in, it may not be 1-to-1 ratio, but it should be within 80% of that. Now, both tests, Shakes test, 4/5 rule, has been considered by the HRTO and has not always been adopted. There are obvious limitations to those rules. For example, Shakes test was rejected by the HRTO in terms of professors getting tenureships, for example. So there are limitations, but it is a tool that you can use. One of the a case that we had was someone who worked in a predominantly, almost exclusively white workplace. She was from Jamaica as a receptionist. She was let go. She was told that they didn't need a receptionist anymore. And then, but she happened to come across a job ad looking for a receptionist, exactly the same job ad that she had initially been hired for, except that it included a language requirement, which was that they need to speak Russian, Hebrew, and English. Now, that was the demographic of this particular workplace. Language is actually not a ground under the Human Rights Code unless language is used as a way to discriminate against certain ethnicities or racial background. So what we did is we actually hired Statistics Canada to tell us how many Black individuals speak Russian, Hebrew, and English. And it was determined that there was zero, not just Black, but racialized individuals who speak all three languages, and that 99.7% of people who spoke all three languages in Canada were white. So that was the argument that we made. We actually went through the hearing. In the middle of the hearing, the actual case settled, so I don't know how it would have turned out. But that may be some of the things that you may have to use. But again, as you can tell from the 4/5 rule or even the statistics that we use, you need to have a certain amount of sample size, really. So it is challenging to prove subtle forms of discrimination. Wrongful dismissal cases faced by Black workers, lack of, I guess, leeway in terms of mistakes or misconducts. Their misconducts are dealt more seriously when it's committed by a Black worker. Again, these are tough to, like, it may be one thing to argue that they were fired without just cause, but it may be very difficult to argue that there was a human rights component to it. So these are challenging to argue. I'm not, of course, I would encourage you to kind of push for that. I'm not necessarily scared off in filing claims, but it may be a discussion with the worker as to the challenge that they face. For example, if you're trying to argue why someone didn't get a promotion, why someone was chosen for the layoff, etc., obviously the employer is going to fight back by cross-examining the worker about all the mistakes that they made, all the ways that they were not maybe a good worker. Now, in ESA anti-reprisal jurisprudence or anti-union animus reprisal jurisprudence, there are some cases that talks about how, because there's no perfect employee, how employers can often use other excuses to justify reasons as to why they fire the worker, and how arbitrators or decision makers, adjudicators, need to be very careful with respect to employers' I guess, rationale when they say why a worker was chosen. Unfortunately, and so you can use that in race context as well. Unfortunately, though, with ESA reprisal, the burden of proof is actually with the employer. And the employer has to prove that they didn't punish the worker because they asserted Unemployment Standards Act right. And the policy reason is that only the employer knows why they fired the person. The knowledge of why they fired the person, why they did not give the person a promotion, etc., is in exclusive possession of the employer's knowledge. So therefore, there's a reverse onus. Unfortunately, for human rights context, there is no reverse onus. The applicant has to prove on a balance of probabilities that they were denied promotion because of their race, or they were fired because of their race. So that's where I think the challenges will be. One of the things that we've been trying to do, although we haven't found the right case or or the client who are willing to do this, or cases always settle. As you know, as you may know, when you're arguing wrongful dismissal cases and when you're arguing damages, you're looking at how long it would take for someone to find a job. And there's many factors that the courts look at, the four main ones being age, length of service, character of employment, and availability of similar employment. What we want to push for is things like race to be a factor when the court is assessing what the notice period should be. Again, you will probably have to back it up with Statistics Canada or some stats and figures, which probably won't be that difficult to find. So if you are doing wrongful dismissal cases and you're representing a black worker, I would encourage you to argue race as a reason for the notice period having to be increased. Of course, gender could be a factor as well. But there's no case law, as far as I know, that has actually looked at race, unfortunately. I know there was some discussions about kind of where to choose forms. I did include it in here. I won't talk about it, but form choosing may come into play in terms of your client may be feeling risk averse. I mean, if you're going to challenge, if you're going to have a kind of outside of the box kind of legal arguments that you're going to make, and there's uncertainty about the chance of success, no cost regimes like Human Rights Tribunal or the Ministry of Labor may be more palatable to your client. Of course, there's pros and cons of each forms. Yeah, and that concludes my portion.
Thank you, John. And thank you, everyone, for joining us today. I see that we've gone a little bit over time, and I do apologize for that. But I feel like I've taken away so much from everyone's presentation today. Lots of concrete ideas. John, what you were saying about like using race as a factor, as a to consider in notice periods. Hadn't thought of that before. Very interesting. And I just want everyone to know that this presentation it has been recorded and will be on our website in a few days. We hope that you will join us on the 22nd for part 2. And in the next 2 weeks, please think of ideas for the case summary that I brought up earlier today, for arguments that you might want to raise in that situation. So thank you all again for joining us today. I appreciate it. I don't think we have any time for questions, but we will see you all on the 22nd.
And if everyone